All right. Good afternoon, everyone, and welcome to our October edition of our In the Boardroom series, where today we are going to discuss establishing relationships and setting expectations in intergovernmental agreements. I'm Sarah Diedrich Kastorf, the Director of Outreach and Member Engagement at the Wisconsin Counties Association, and I have the honor of serving as your host slash moderator for today's session. Before I turn it over to our esteemed panelists for today, I'm just going to make a couple of quick announcements. First, if you have any questions throughout this webinar, please feel free to use the chat or the Q&A feature, which are located on the bottom of your Zoom screen. We will be monitoring the chat and the Q&A throughout the presentation. Just keep in mind that if we do not get to your question as the presentation is going on, we will get back to all of the questions during the Q&A period at the end of the formal presentation. The second thing I will make note of is we are recording this webinar, and this recording, along with the PowerPoint slides, will be available on the WCA website at www.wicounties.org. In the upper right section of our website, you will find a button called Past Event Materials. Click on there, and that will take you right to our page where all of the 2025 and 2024 in the boardroom webinars and their associated materials can be found. So with that, I am going to turn it over to Andy Phillips and Rebecca Roker from Attolles Law, who will talk to us today about this very important topic.
Awesome. Thank you, sir. Good afternoon, everybody. This is a topic that's near and dear to my heart, dealing with intergovernmental cooperation, intergovernmental agreements, trying to figure out how it is as counties we move forward in an era where we have decreasing revenues, imposition of levy limits, increasing responsibility in all of this. And so Rebecca and I have worked an awful lot on intergovernmental agreements over the years, and so we're happy to share our knowledge about these particular contracts with you all. I want to start with the title slide. You'll see they're doing more with less with a couple of question marks. How in the world are we supposed to do more with less? And I'm going to ask this question. It's a bit of a rhetorical question, but it's a question nonetheless. How definitionally can you do more with less? I think it's impossible. And so we're going to talk about how we maybe take a look at doing things differently as opposed to trying to do the same thing with less resources. And so in talking about the presentation today and what it is that we hope to cover, we look at a whole variety of topics, and it's hard to organize this into a streamlined presentation, meaning some of these topics don't flow exactly and precisely into the next topic. There's no good transition. And so we've got 8 different headings that we're going to talk about today. Some of them relate to other topics, some of them do not. And so we're going to bounce all over the place today. It's a very long-winded way of saying that we're going to cover a lot of ground and we're going to hit it at a very high level. But if you want more information, if you're thirsting for more knowledge about any particular subset of these topics, let us know. And we can either talk with you individually or set up a round 2 of intergovernmental agreements where we do a deeper dive into the discussion. But this is the basic agenda we're going to follow today. We're going to talk about, just in basic terms, what is an intergovernmental agreement? What does it mean to administer an intergovernmental agreement? How does all of this relate to the Innovation Grant Fund, which was authorized in 2023 Act 12? What are some contract basics? What are some benefits of intergovernmental agreements? What is the thought process behind entering into these agreements? What are some of the risks associated with them? And then what are some of the drafting considerations? So before we do a deep dive into section 1 of this, Rebecca, anything you wanted to add just at the start, at the outset, to get everybody in the right frame of mind, if you will?
No, but thank you. It's great to be here, everyone. I think you covered everything well, Andy, so I'll let you keep going.
All right, we'll keep going. Let's start with the intergovernmental agreements and overview. So what is an intergovernmental agreement? It's defined in 66.0301 of the statutes, and it's defined very simply as an agreement for the receipt or furnishing of services or the joint exercise of any power or duty required by law. All right. It can be used for mandatory services or discretionary services, but there are some important terms contained within this definition. Number one, it's an agreement. All right. So it can't be something that is just done without a formal or informal, for that matter, understanding, meeting of the minds between the parties, what we would all consider to be a contract. So it has to be an agreement or contract. Has to relate to the receipt or furnishing of services, not goods, services, or the joint exercise, meaning the two entities or two or more entities get together and jointly exercise any power or duty required by law. So that is an authorization limitation in the definition of intergovernmental agreement, meaning are the parties to the agreement authorized or required by law to do something? All right. So as we do a little bit deeper dive into the statutes themselves, we see the actual verbiage in 66.0301. And right in there, again, we have the provision that we just pulled out and put on the previous slide, in addition to other provisions specifically authorizing cooperation. So this is all considered an umbrella. 660301 is like the umbrella statute which authorizes intergovernmental cooperation. Any municipality can contract with other municipalities and federally recognized Indian tribes and bands in this state for the receipt or furnishing of services or the joint exercise of any power or duty required or authorized by law. Remember, I talked about this whole authorization point where it says a power or duty required or authorized by law. That's what we can do to the extent of joint exercise under one of these intergovernmental agreements. If there are parties to the contract that have varying powers of or duties, each can act to the extent of their lawful powers and duties. As you might imagine, a city or village's powers and duties, while similar to, are not the same as a county's. So we can't have a city or village exercising county powers under a contract, and likewise, we can't have a county exercising city or village powers under a contract. We have to make sure that each party to the contract is exercising authority that it already has under the law, and it is going to exercise that authority within the confines of that agreement that we are putting together. All right.
Andy, can
I
I
think,
first ask
go ahead.
I have a quick question. And we may cover this later. If you've got a city and a county in an agreement, the city can still perform its duties that a county may not have, correct? So
Correct.
we look
Yes.
at each individual entity and what their powers are in performing those services. Is that
That's
right?
exactly right. That's
Okay.
exactly right. That's how we should think of it. And the last sentence that we've got here in the excerpt of 660301 is, I think, important as well. And we always speak to this in terms of the way we interpret and apply 660301 whenever we have questions that come up about our ability to jointly exercise powers or contract for the receipt or furnishing of services. It says this section shall be interpreted liberally in favor of cooperative action between municipalities and between municipalities and Indian tribes and bands in this state. So it's important to understand that unlike what we've got with the public records law or open meetings law, as there is a liberal construction in favor of transparency. So there is basically an understanding that when a court looks at a particular situation, it's going to view a county's actions, for example, in withholding records under the records law or going into closed session or something like that, with a bit of a critical eye to say, is that really promoting transparency? Here we've got a situation where the law says that we are going to liberally construe this section to encourage cooperation between counties, municipalities, Indian bands, and tribes within the state. So I think that's important. We have a separate statute that also impacts our ability to cooperate with other counties and other municipalities. And that's 66.0131 sub 2. Notwithstanding any statute requiring bids for public purchasing, any local governmental unit may make purchases from another unit of government, including the state or federal government, without the intervention of bids. All right. So I want to make clear here, though, that 66.0131 sub 2 applies to purchases that do not otherwise fall under the umbrella in 59.52 sub 29 that say we have to go out on a project of public works and solicit bids and then award the bid to the lowest responsible bidder. That's not what this statute does. It's not a workaround for that. But With everything else, we have the authority under statute to purchase materials from our municipal and county counterparts and colleagues around the state. So I want to make sure that everybody understands what 660131 sub 2 does. The other thing I will point out, and Rebecca and I have some experience with this as of late, is if there is another statute that impacts a county's legal authority to either sell or purchase goods, that a specific statute in that circumstance will likely apply over the general authority here in 660131 sub 2. So what I'm thinking is that we have the ability, I think it's in chapter 83, 84, or 86, to sell road materials to municipalities within our county. That statute that specifically addresses county authority to sell those materials to a municipality within the county is going to control over 66.0131 sub 2. So I just wanted to make that point clear. And then we have 59.52 sub 7, which deals with joint cooperation. This statute was amended in large part in 2014, I believe it was, and it was an effort by the Counties Association to allow for greater cooperation when it comes to operating joint departments, joint units, joint programs, and things of that nature. The reason this statute came into existence, or at least in its modified form, is because of the difficulties that Washington and Ozaukee County encountered when they wanted to operate a joint health department. When they wanted to operate a joint health department, there were all number of statutes which told the counties that they had to get permission from this, or do X, or do Y, or do Z before they could enter into a contract to operate a joint health department. And instead of looking at the very broad authority in 660301, the regulators, the state and others were looking at it and saying, no, you've got to follow these specific statutes. And that's where WCA stepped up and said, that doesn't make any sense. Why should we have to evaluate on a case-by-case basis our ability to do something? Why can't we have this big catch-all which allows us to essentially combine and operate jointly these programs, these departments? And so that's what you see in 59.52 sub 7, is that if counties enter into a cooperative arrangement under 660301, we have the ability to jointly operate with another county, carry out the responsibilities that would otherwise be incumbent upon each individual county under normal statutory authority. So 59.52 sub 7 is really important when we're dealing with joint powers, we're dealing with cooperative arrangements between counties. So who can enter into an intergovernmental agreement? I keep using the term municipality, and I'm sure a lot of you are thinking, well, does that mean that we're limited to partnering with cities and villages? And the answer is no. If you look at the definition of municipality, this is in 660301 sub 1, the provision under the statutes defining municipality is quite broad, and it includes city, village, town, county, school district, and a whole series of other entities that we consider to be public agencies under Wisconsin laws. So there is a quite broad definition as it relates to municipality. One important concept here, though, is that even though the state and a department or agency of the state is included within the definition of municipality, the federal government is not. And so if you want to have a contract with the Army Corps of Engineers, the Army Corps of Engineers is not recognized as a municipality under Wisconsin law for purposes of 66.0301. And so we'd have to look at other sources that give us the ability to enter into a contract with, for example, a federal agency such as the Army Corps of Engineers.
Andy, can I jump in real quick?
Go for
it. If you wouldn't mind going back to the last slide, when we're talking about what is a municipality, to kind of cross-reference our in the boardrooms, we'll note that municipality includes a public inland lake protection and rehab district, which is a lake district. And so counties may be receiving requests from lake districts to enter into the intergovernmental agreements. And this is a place where I think we need to be very careful in a county not agreeing to do something that exceeds its authority under Chapter 59 or elsewhere in the statutes. So just wanted to give a heads up on that is, again, a crossover between our different topics, but also something that we're starting to see in requests to counties from these lake districts.
Well, and I think that brings up a good point, and that is this is really a very high-level discussion of intergovernmental agreements. And a lot of these agreements require counties to get into the weeds of the legal analysis about authority, responsibility, and so on. And we'll see as we go on in our discussion today, there are complexities with these agreements, no doubt about it. Involve your corporation counsel early and often in these discussions because your corporation counsel is going to be able to pinpoint the areas of concern as it relates to these agreements. And if the corporation counsel says, look, this is even beyond what I typically do, let's bring in somebody else, that's when you bring in outside counsel to assist in the evaluation of the appropriateness of a particular contract, the extent of your county's statutory authority or responsibility, and for that matter, the extent of the counterparty's responsibilities and authorities. So we get into some complicated legal issues here, and so involve your corporation counsel early and often in these discussions. As I mentioned, from a basic standpoint, we have two basic things that we're talking about here. We're talking about either the receipt or furnishing of services or the joint exercise of any power or duty required or authorized by law. And then, of course, in 59.52 sub 7, as I discussed earlier, we have the ability to carry out a responsibility jointly as opposed to individually. What is an example of that? Well, we've got North Central Community Services. That is an agency created by Langlade, Lincoln, and Marathon counties. Those three counties combined, so to speak, to create one singular Department of Community Programs. And it is through that joint department that community programs and the authorizing programs and so on are carried out within those three counties. Same goes for Unified Community Services or Unified Board down in Grant and Iowa counties. And so we have examples out there, in addition to what I mentioned earlier with Ozaukee and Washington counties combining their health departments, we have examples out there of counties getting together and jointly cooperating for purposes of delivering these really important services to our citizens. So again, to Rebecca's point earlier, how important it is as an initial matter to figure out where the statutory authority is for the underlying duty that a county will perform in an intergovernmental agreement. We have to have that authority individually before we agree to perform a certain function under that authority under an intergovernmental agreement. So we can't do, think about it this way, we can't do through an intergovernmental agreement what the law would not recognize us as being able to do were we to do it on our own. Okay, so again, it's very, very important that we understand and we're careful about defining the scope of a county's authority under the intergovernmental agreement. I stated this before, and I think this is a very important sentence contained within 660301. It's entitled to liberal construction in favor of cooperation. So when we talk about an intergovernmental agreement, they can be simple agreements where, for example, one county agrees to plow a particular road over another county's border for a period of time because it's just easier to go an extra quarter-mile stretch of a road and then turn around and come back as opposed to having the county where the road is located perform that plowing function. That's a simple agreement. But then we also get into some complex agreements. As I mentioned before, as you might imagine, with multi-county departments of community programs, multi-county health departments, there's a lot to be ironed out in the context of those agreements. In certain circumstances, we may want to have a body that exists independent of the two county boards or two county board committees that is going to administer the contract. We want a body that is focused on the joint cooperation. Well, 66.0301 sub 3 through sub 5, that statute, those subsections allow a county to create a commission vis-a-vis an intergovernmental agreement. The agreement itself may provide a plan for administration. Again, it's not required, but we can provide a plan for administration of the function or project, which includes creation of a commission, selection and removal of commissioners, and formation and letting of contracts. Great. So what is a commission in this circumstance? Well, a commission is just what you would think about as being a body that is dedicated to administration of an intergovernmental agreement. Frankly, it doesn't matter what you call it. The statutes call it a commission, but there are, in certain circumstances, counties to IGAs that have called them supervisory committee, uh, advisory, whatever they want to call them, but they are considered a commission under these particular subsections of the statute. Those commissions that are created through the intergovernmental agreement have independent authority. They can finance the acquisition, development, remodeling, construction, equipment of lands and buildings under certain statutes and so on. There are also limitations on what a commission can do in statute. But what I will tell you is this, is that it makes sense that if counties are getting together under an intergovernmental agreement and they decide that they need a separate body that is responsible for administration of that intergovernmental agreement, we ought to clearly define what it is that we are authorizing that commission to do. And we ought to clearly define what it is that we are not authorizing that commission to do. In other words, we are defining what the commission may do to administer the contract and what the commission may not do. Where in certain circumstances a commission has to come back to each of the counties and request permission. I'll give you an example. With what I talked about before with North Central Community Services, it was very important that the counties not relinquish complete oversight as it relates to personnel administration and finance in that joint Department of Community Programs. And so what the county said is that we're creating a commission that is essentially going to administer the contracts, but whenever it comes to personnel administration or finance, budget, we need to come back to the counties and ask permission to do certain things. All right. So it's very important that we understand and appreciate the level of discretion we are giving a commission and when it is that a commission must come back and ask the counties for permission. Before I move on to speak specifically to innovation grants under Act 12, Rebecca, anything you wanted to add just on the overview of intergovernmental agreements?
Yeah, jumping back to the creating a commission, Andy, is this where we would designate a lead agency? Or if we have a lead agency within our intergovernmental agreement, could we assign lead duties as part of that commission, whether it be, the chair of the commission or representation on the commission? How much flexibility do counties have in the creation of the commission and the structure?
They have total flexibility on that. I'm thinking of the Medicaid nursing home commissions that were created about 15 years ago in Dodge, La Crosse, and Clark counties. We found over time that the easiest way to get a lot of things done was to designate a county as lead county agency as it relates to finance and other issues. And so you see within those intergovernmental agreements, the designation of Clark, La Crosse, and Dodge counties as the lead county agencies on those issues in the intergovernmental agreement. So yes, that is an opportunity where if one county says, I want to take on personnel administration, we want to administer personnel within this joint department, if you will, then you just simply say in the intergovernmental agreement that X county is responsible for personnel administration and is the designated lead county agency as it relates to personnel matters. Absolutely, that's a very good point. All right, so let's talk a little bit about these innovation grants. I think that a lot of counties have heard an awful lot about Act 12 and the innovation grants in the program. Thankfully, DOR recently came out with guidance as to how to apply for innovation grants and the certain requirements associated with these innovation grants. So the statute that authorizes the innovation grants is 79038 sub 1 sub A. It says that counties and municipalities may apply in the manner and on the forms prescribed by the departments. They may apply for innovation grants to implement innovation plans. Now, look at the definition of innovation plan. It's a plan submitted by a county or municipality to transfer services or duties, all right? It's not to combine and jointly provide, it's to transfer services or duties. Transferring those services or duties to another county, a municipality, a nonprofit, or a private entity. So I want to be very careful here that when we're submitting for payment of an innovation grant that we are submitting and saying we are transferring our responsibility for a particular service or duty to another county or municipality or the private sector. And this is the money that we're going to save in doing so. All right. So what qualifies as a service or duty that can be transferred? It has to fall within one of the categories delineated in A through N of 79038 1B1. When you look at this, it's very broad, all right, but it's not all encompassing. It's very broad, but it's not all encompassing. When we have A through N on this list, you will see one glaring omission that is in every county budget, and that's human services. We don't have human services on this list, but we have an awful lot impacting county budgets that is on this list. So understand too that we're limited in terms of what we can do in terms of qualifying for an innovation grant and the services or duties that we transfer, but it's not everything within county government. And so we have certain requirements as it relates to the intergovernmental agreement that will effectuate the transfer of a service or duty. All right. The intergovernmental agreement has to meet certain conditions. It has to contain all of the following, and that's A through E of this particular subsection or paragraph of the statute. We have to specify the services or duties to be transferred. We enter into this agreement no earlier than the notice date under Act 12, which we're fine on that one now. At least 3 years. That agreement has to go for at least 3 years in terms of the transfer, all right? And the cost has to be, there is a function in there of evaluating what the cost is right now and what the cost will be after the transfer. And we have to save money as a result of the cooperative relationship that we are establishing through the intergovernmental agreement. All right. We have to allocate the grant monies between the counties or municipalities that are parties to that particular intergovernmental agreement. And so again, it's important that we understand what qualifies for grant funding, and then also what the IGA requirements are associated with that particular grant. In addition, the Department of Revenue has promulgated regulations to implement the Innovation Grant Program. That's in the Administrative Code section. The chapter is Tax 21.05 sub 3. And there are certain requirements as it relates to Department of Revenue's ability to audit compliance with the statutory provisions, audit the intergovernmental agreement, to make sure that everything that we say was going to happen is actually happening or has actually happened. So why do we have all of this in here? Why is this important? Because all of this information is contained on the grant application. So we fill out the form, we submit it to the Department of Revenue. Baked within all of these requirements is, at least in the mind of every lawyer who's going to look at this, a thought saying, how do we address this in our IGA? How are we going to address this? Who is responsible? Which of the parties is responsible for doing all of these things? Does it make sense to set up that commission, that separate body, to make sure that we do all of these things in these agreements? If we get audited, who's responsible for the audit? If there are certain costs or expenses or disallowances in the Department of Revenue audit, who bears responsibility for taking care of that issue? It's an allocation of responsibilities under the intergovernmental agreement that is really, really important, not only for purposes of compliance with statutes, but also to make sure that the parties to that intergovernmental agreement understand who is responsible for those items. So again, that's very important in terms of drafting considerations within that intergovernmental agreement. All right. So again, get into some complicated things. Talk with your corporation counsel early and often. And ultimately, I'm going to tell you what the goal of a contract that qualifies as an IGA under Act 12's Innovation Grant Program is the same as a contract requiring or allowing for the joint provision of services, or a contract that is a simple contract where we're going to purchase services from another county. All of these contracts are contingent upon or rely upon each party getting the benefit of their bargain. Why are they entering into the agreement? What is it that we hope to accomplish? The job of corporation counsel and the lawyers who help in drafting these agreements is to ensure that each party gets the benefit of their bargain, to make sure that the parties understand what they're contracting for and understand what it is that the parties are getting as a result of that contract. And that's a point I want to make here. An intergovernmental agreement is a contract. And so it's governed by all of the legal principles associated with interpretation and application of a contract, any other contract recognized under the law. So again, it's important. It doesn't matter what you call it, all right? If we see what the authorizing statute says, it clearly says that this is a contract. And so I'll ask the question, what's the difference between a contract, an agreement, an MOU, an MOA, and a covenant? There is no difference. No difference whatsoever. And so I know in our careers, Rebecca and I have at various times heard counties say, well, I don't have a contract. I just have an MOU. No, I'm sorry. That MOU might be a contract. An MOU doesn't always have to be a contract, but if it walks like a duck, if it talks like a duck, if it quacks like a duck, it's a duck. If your MOU meets all of the requirements of a legally binding contract, it is a contract. And taking us back to the very first day of our contracts class in law school, there are 3 elements to a contract: offer, acceptance, and consideration. If you hit those 3 elements, you've got a contract. I don't care what you call it. All right. So again, it's very important to understand what we're dealing with here, and that is contractual obligations. So along those lines, I've had this discussion with counties over the course of, I want to say, the last 10 to 15 years about how to evaluate and look at contracts. When your corporation counsel looks at contracts, when we as outside counsel come in and look at contracts, we aren't reading it like a novel cover to cover and understanding. We're looking at certain elements of a contract to figure out what it is that a county is obligated to do or the benefit a county will receive under a contract, and what the various other conditions are that impact a county under a contract. So we developed this roadmap for contractual success. All right. We have 5 big, broad questions at the top, and then we have a series of sub considerations under these big considerations. All right. I'm not going to go into detail on all of these things here, but we put this roadmap in this presentation to basically reinforce the notion that we're dealing with contracts here. So even though we call it an intergovernmental agreement, the same contract considerations, the same roadmap applies in equal force here. And so we put this here where you can refer to this after this particular in the boardroom discussion is done. You can have a conversation with your corporation counsel, or if you are corporation counsel, you look back in drafting and say, okay, are we addressing all of the things that we need to address in this intergovernmental agreement? Now, I will tell you that the last half hour's discussion about commissions, about requirements under Act 12, about all of these other things are going to add to the list that we see here. But this is the basics. This is the roadmap to make sure that we are addressing everything we need to address within our contract. All right. Before I move on, Rebecca, anything you want to talk about? Because I know you've heard people talk about, oh, it's not a contract, it's an MOA.
Probably the most frequent I hear is it's not a contract, it's just a letter agreement that we both signed. Again, I love the Contracts 101 first day of contract class in law school. You look at those basic elements, and if your letter agreement has offer, acceptance, consideration, that letter agreement is a contract. So yeah, I think the point of it doesn't matter what you call it, you have to look at the elements is a great takeaway. Real quickly on the roadmap, and perhaps this is an opportunity for IGA's part 2 in the boardroom. A lot of these elements, such as indemnification, jump out at me as ones that really require legal assistance and overview. So, we as lawyers and all of the corporation counsels look at these elements to understand the the goals of the contract, but then baked into those are very particular legal issues, such as indemnification. And then those in turn raise questions of what is a county's authority to agree to certain indemnifications? Are there limitations on what you may agree to in a particular intergovernmental agreement? So just wanted to touch on those two items.
Well, I think that's a good point, Rebecca, and it brings to mind, at least in my mind, your statement earlier about this concept of a lead county agency. It's awesome to have a lead county agency that is going to assume responsibility, for example, for personnel administration under a cooperative arrangement. Awesome, lead county agency is responsible. What if lead county agency messes up? Is lead county agency going to indemnify the other county or counties in that agreement because it messed up as the lead county agency? I think that would be appropriate, but that's something that ought to be addressed in your IGA, 100%. Very good point.
One other quick thing on that, Andy, maybe a little off topic, but we get questions often on what is a county's authority to indemnify. And that's a very deep dive question, but I just wanted to throw that out there for all of our participants, that sometimes that there are constitutional questions of the extent to which a county may agree to an indemnification. So just a warning out there when folks are looking at these types of agreements or any contract, that indemnifications may raise some deeper dive issues.
Well, and not to crawl down the 43rd rabbit hole of this discussion, but when we're talking about intergovernmental agreements, recall the definition of municipality includes the state and its agencies. And so counties can contract with the state or its agencies for the receipt or furnishing of services. The state definitely has limitations on what it can do in terms of indemnification. We need to be aware of those so that we address those in the IGA relating to the contract with the state. The same with an Indian tribe. Native American tribes, they have what's called sovereign immunity. That can be a big deal in these IGAs because if they don't waive sovereign immunity, you may have indemnification in a contract, but you can't enforce it. And so this just illustrates some of the complexities that come up in these IGAs and the need, again, to have corporation counsel involved early and often. And again, if this extends beyond the expertise or the bandwidth from a time perspective of corporation counsel, bring in outside counsel to evaluate these things. This is really, really important stuff. All right. Kathy asked the question. I'm going to address this very quickly. When are the slides available and where? Sarah addressed that at the beginning of this. It's wicounties.org under past event materials. As soon as this recording is downloaded and available, it'll be posted along with the slide deck from this presentation. So benefits of intergovernmental agreements. And this is where we get into more of what I will call the squishy stuff as opposed to the legal stuff about what an IGA contains. Why would we look at an intergovernmental agreement in the first place? Well, three general reasons based upon our experience: to improve the quality of services that we're providing to the public, to generate cost savings as a result of those services that we're providing, or to create efficiencies in administration of a service offering. That's primarily where we see counties wanting to get into IGAs. So again, we're combining resources to increase the quality of the services that we provide. We may have a particular county that's really good at X, another county that's really good at Y. You put them together and they're really good at X and Y. And so you're going to put them together in a cooperative relationship in order to jointly provide those services. When it comes to mandated services, all right, we may have to pool our resources in order to meet our mandate. All right, the list of mandates is not decreasing. The list of mandates is increasing. What are mandates? Could come about as a result of state law, could come about as a result of federal law, whatever it is. We know as counties that we don't have the opportunity to say, no, we're not going to do it. We're required to do it. So how do we get it done with the limited resources we have? We pool our services with some of our other counties or municipal counterparts in our area. This is especially critical in rural areas where we just don't have a lot of resources available. I started with this on the title slide of this presentation. Doing more with less. It makes the hair on the back of my neck stand up when I hear people say, "Oh, we've got to learn to do more with less." No, you can't do more with less. Definitionally, it's impossible to do more with less. You cannot do more with less. But what you can do is you can do things differently. And so what does that look like? How is it that we can either maintain or increase our service levels by doing things differently? That's the question we ought to ask ourselves when we evaluate the benefits or the detriments associated with an intergovernmental agreement. If there's operational efficiency that we can achieve, let's explore that opportunity. And again, I'll say this for the 23rd time, involve corporation counsel in those discussions early and often. But then you're going to ask, well, how do we get there? How do we evaluate this? How do we make a determination about whether we can be more efficient or we won't be more efficient? What do we do? Well, that's a process as well. All right. I'm going to start with this. And this is true of every contract. It doesn't matter if it's an IGA or a contract to purchase an automobile from your dealer. The contract is going to depend upon the goodwill and good faith of each party to that contract. Good lawyers will figure out how to get somebody out of a contract. Good lawyers will tell you how to create problems under a contract, but we don't want that. All right. We want parties in a contract who, in good faith, are going to enter into a relationship with an eye toward success, not an eye toward getting out of the contract, an eye toward success. All right. So if you have parties that are willing to work together, it is incumbent upon the lawyers to write a contract that, again, reflects what it is the parties want to accomplish under that contract. All right. So again, there has to be a high degree of trust between the parties to an intergovernmental agreement for that IGA to succeed. Very important.
Andy, can I jump in here?
Yep, go ahead.
Because I have one matter on my desk right now that it really is requiring a high degree of trust between the parties. There's lots of things we can't promise are going to happen. And so inherent in every contract is that duty of to act in good faith. But we can also specifically state that in a contract, and we can even put what I'll call, the fuzzy warm language of a commitment by the parties to work in cooperation, to identify that heightened sense of commitment to the project, or that acknowledgement of working in good faith. So that's something that, if we need to emphasize it in the contract, we can do that. Now, does it impose a higher threshold in a contract? No, it's just kind of warm and fuzzy language that we can include.
It's warm and fuzzy, but it's important. And it's important because 15 years from now, when we have a completely different county board, completely different county administration, completely different department head looking at a contract, they see within the recitals what the intent of the parties was at that time so that they can evaluate, are we doing everything that we said 15 years ago that we wanted to do? And I think that stuff is all helpful. So things that you and I, Rebecca, say warm, fuzzy, it isn't necessary to the contract. We're right, it's not necessary, but I think it's good to have there to basically tell the story. I'm a big proponent of telling the story within the recitals. Let's figure out how we got here so that somebody looking at this agreement far down the road is going to be able to understand exactly why we're doing what we're doing. I think that's
Yep. Yeah, totally agree. And I will say too that even though from a legal standpoint, the warm and fuzzies may not get us there, man, if it can get us over that hump of getting it done, let's put it in there. I'm a big fan of that too. So I'm with you,
I agree.
Andy.
All right, before I move on to the next section, Chris asked a really good question here. He said that during the county leadership meeting that we had on Monday, Valia Foy from the Department of Revenue said that transfer of services or duties to an RPC, a regional planning commission, would not qualify for innovation grant funding. And she was 100% right. And Chris says, well, wait a second, did I miss something? Because in the definition of municipality that we had on the screen about 15 minutes ago, RPCs, commissions, regional planning commissions were included in the definition of municipality. No, you're right, Chris. They're included within the definition of municipality. So we have the ability to enter into intergovernmental agreements with a regional planning commission. But if we transfer a service or duty to a regional planning commission, we cannot make claim for innovation grant funding to DOR. Okay, so big distinction there. We have the ability to contract with an RPC. We just can't make a claim to DOR for innovation grant funding through the transfer of a duty or service to an RPC. Wanted to make that clear. All right, this I stole with permission from Tim Hanna at the Local Government Institute. Tim Hanna and I go way back talking about concepts of collaboration and ways that we can encourage efficiency through intergovernmental agreements, through cooperative planning, and so on among municipal entities, including counties. And so I know the Local Government Institute has been focused on trying to create a platform where counties and municipalities can evaluate the benefits or potential benefits associated with intergovernmental agreements. And I thought this slide was fantastic in terms of defining this whole trust versus turf issue. Oftentimes, the biggest impediment to intergovernmental cooperation is the government entities that are potential dance partners saying, no, we always like the way we've done this. We want to continue doing it on our own. It's really, really important that we do it on our own. And I completely understand that. All right. Completely understand it. But how do we get beyond that particular barrier and get to a trust environment where we can have an honest and open discussion about the ability to cooperatively provide a service or share in the provision of a particular service to the public? And so this is a continuum where we move from turf, where we compete with one another, to trust, where we fully integrate on this. And so if you're considering entering into a collaborative relationship, or you're looking at opportunities, pull out this chart and say, where are we on this continuum? Are we in turf? Are we in trust? How do we move from turf over to trust? I think it's a really good example of what we can do. So who's the appropriate dance partner that we're talking about? Well, I think it starts with just either a committee of the county administration, board and administration, committee and administration, taking a look at what are the objectives or the problems that need to be solved as a result of a particular mandate or a particular issue that's confronting the county. And is there a way that we can leverage the resources from another county to jointly do something or to share in some certain mandate or responsibility? Are there limitations on who we can partner with? Those limitations may be geographic. We may be limited in terms of our authority as counties. Remember, we can only contract to the extent of our authority under existing law. So are there restrictions on our powers that would somehow inhibit our ability to cooperate? We want to engage the potential partner. In what way? Do we start with administration? Do we start with committees? Do we start with boards? How do we engage with our particular partner? And there is no right answer for any of these questions. These are just considerations that we need to think about. Then once we get to the point where we say, okay, it would make sense for us to enter into an IGA with our neighboring county for the joint provision of services or the joint exercise of powers. Well, let's commit to a term sheet that have these parameters. What I mean by that is that in drafting parlance, typically the parties negotiate what's called a letter of intent or a term sheet before they commit to a contract. What that does is basically provides the intent to the drafters, meaning that the lawyers would get the term sheet and be able to look and say, okay, I know how to draft this contract based upon the intent reflected in this term sheet. So have the business people, if you will, the county folks, draft the term sheet saying what it is that we want to accomplish, and then legal will draft up the contract to meet the goals as evinced within that term sheet. Now, that doesn't mean that legal isn't involved in the term sheet. As Rebecca would tell you, I would tell you, every corporation counsel will tell you, we need to be involved in drafting the term sheet because we're the ones that tell you, here's what you need to address, all right? But it's that term sheet that provides the foundation for the eventual intergovernmental agreement. I don't want to make it sound like IGAs are always rosy and they're wonderful. They're not. There can be pitfalls. There are risks associated with IGAs. Whenever we relinquish control, whether it's to a commission or another county or another municipality, that's frightening because we are accustomed to doing things ourselves. So there are risks and pitfalls within IGAs. We have to make sure that we address governance and accountability so we don't inadequately blur lines of responsibility, making things more complex than they already are. There could be funding disputes as it relates to cost sharing within an IGA. What is the public perception of the IGA? Is the public fearing more bureaucracy and a loss of local control? And then there are legal complexities associated with these contracts. Now, all of these things are potential risks and pitfalls, but if you ask Rebecca or ask me, we view these as potential opportunities. Opportunities to address these risks and pitfalls within the IGA itself. And so again, make sure that when we're talking about the term sheet, when we're talking about the draft IGA, that we are working with legal to ensure that all of the things that could cause problems are being addressed to the best of our abilities within an IGA. Now, why did I say to the best of our abilities there? Because I don't care how good a lawyer is, there is no way that a lawyer can predict the future and identify with precision each pinch point or pain point that is going to arise as a result of operating under an IGA. But what every lawyer can do is make sure that to the best of our abilities, we address these issues up front and we provide a procedure to resolve these issues when they arise in the future. So we get into drafting considerations when it comes to these IGAs. The commitment, and you're going to see consistency between these next slides and that roadmap for contractual success that I put on the screen about 15 minutes ago. So first, we talk about the commitment. How long is this commitment going to last? Are we just testing the waters, or are we going to full-scale integration that's going to have a long-term impact? Is the contract going to have an evergreen clause where it automatically renews? And if a party wants to leave the contract, what type of notice is required? What's fair and equitable under the circumstances? What happens if one party fails to perform or is alleged to have failed to perform? What's going to be considered a material breach of the contract, and what happens if we have material breach? Is it going to be automatic termination of the contract, or is there going to be some other remedy? Who's the decision maker for each party to the contract? Who gets to declare breach? What is the purpose and scope? I talked before about a meeting of the minds or benefit of the bargain. What is the purpose and scope of the IGA? And this is an opportunity within the recitals clauses at the beginning of the contract to really talk about the intent of the parties and why it is that we are looking at an IGA in this circumstance. All right. It documents the party's intent. The scope is very important. Who's going to do what for whom, when, and under what conditions? We want to make sure that that's adequately identified with particularity within any IGA. Then we get into dispute resolution. I talked just a moment ago about how no lawyer can predict the future, and that's true. But what a good lawyer can do is provide the parties with a dispute resolution mechanism so that even the unforeseen is capable of resolution within the confines of that IGA. The one thing we don't want is counties running off to court suing each other. That's not good. All right. Not only is it time consuming, not only is it expensive because we're paying lawyers to resolve this dispute, but it looks bad. All right. It's bad optics to have counties suing one another. All right. So let's build a dispute resolution mechanism into the IGA, depending upon the complexity of the IGA and the services or duties that are being offered and received under the IGA. We might want to bring in third-party expertise to assist us in resolving the dispute. That's called mediation. And so again, this isn't one size fits all, and I don't want to suggest that there is a magic bullet that says this is the perfect dispute resolution mechanism, but these are certainly considerations that we want to make sure are addressed within the context of our IGA. So we've now hit 12:53. We have 7 minutes left. Before we get to questions, Rebecca, anything that you want to talk about in particular? This is a topic that is incapable of doing anything other than the 30,000-foot level at this point. And there are so many considerations that we've seen over our careers with intergovernmental agreements. But just from your standpoint, what are some of your thoughts as we talk about IGAs and their importance here?
I think IGAs present a great opportunity for counties to get creative. As you indicated, Andy, that expectation of more with less, and we're bound by what we can do under the statutes. So identifying what that end goal is and how we can be creative to get from point A to point B is one of the favorite parts of my job. And coming up with those creative solutions to get counties to where they want to be in their vision is really fun. And so I think those same opportunities can be positive experiences for, different county departments or staff, and present opportunities that, people may not have even thought of before. So I just wanted to point that out that these can be fun opportunities to really get creative, of course, within, the legal restrictions that counties face.
Yeah, and that brings up a good point, Rebecca. I often make the joke that nobody ever calls us and says, I'm doing fine today. How are you? Everybody usually
Mhm.
calls us with a crisis or a situation where they need help immediately. This is one of the rare circumstances where we get the phone call and it's exciting. It's fun to hear that voice on the other end say, Hey, we're thinking about doing things a little bit differently. We're thinking about partnering with our neighbor county to do X, Y, and Z. Can you help us with that? That's exciting. That's
Mhm.
fun. How can we create efficiency? How can we do things differently so that we get some relief from the mandates, from the levy caps, all of those things? I think that's a lot of fun to put these together. And so I hope that everybody that's on this webinar has the same level of enthusiasm for attacking some of these things that we do. It can be really fun to your point, Rebecca.
Mhm.
So now we got 5 minutes left, and I'm wondering if the audience is either A, asleep, or B, we've answered every question that they could conceive of because I don't see any open questions in the Q&A or the chat. And Sarah, I don't know if you have any questions because we do have 4 minutes left, but we are happy to identify or speak to any questions that you all may have. Just drop them into chat, drop them into Q&A.
Yeah, I have no questions for you, Andy, at this time, but while we wait for more questions, maybe I'll use this opportunity to talk about our November in the boardroom.
Go for it. This is one I know is near and dear to Rebecca's heart, so go for
It
it.
is. It is November 19th, Wednesday, November 19th, again at noon. This is going to be part two of the in the boardroom on short-term rentals. I think for those of you who join us on a monthly basis, just a few months ago, we had our in the boardroom on short-term rentals along with a conference program, and I think we could probably do a 6 month series uh, on short-term rentals. We didn't get anywhere near the questions answered and through the whole presentation, even though we stayed on, I think, for an extra 30 minutes. So again,
Mhm.
join us November 19th for part two of In the Boardroom on Short-Term Rentals. Andy, I think I see a question that popped in, a couple of questions now that are in the Q&A.
I do here. So we've got a question from Rachel about what can counties do to encourage agreements between bordering cities and towns that are interested? That's a great question, Rachel, because it's basically saying, how do we start the conversation about creating efficiencies here? You may want to consider the creation of an ad hoc committee from the county board and include people or representatives from various towns, cities, villages to have a discussion about opportunities for efficiency. It's an ad hoc committee with no final decision-making authority. Of course, it would have to go back to each governing body or governing board to make a final determination on anything, but at least having a forum where you can start the discussion, maybe that's a good idea. Informally, administration from the various governmental entities could get together and start having those discussions. But whatever you do, I think, and maybe Rebecca or Sarah, you have other ideas, but I think having a forum that is dedicated to the discussion is a fantastic starting point, a launch point for these intergovernmental agreements.
Yeah, I would agree with that, Andy. And even a precursor to that forum, oftentimes opportunities or inventions are created out of need. That's where, encourage department directors or people who are in those specialized areas, to identify unique situations in those areas. So maybe through professional associations, a director becomes aware of a challenge that they identify in their department, but maybe a city and village has a similar challenge. Then encourage that department director to bring it forward. And then, our leadership can look at establishing that ad hoc committee or that other forum, to have that more robust and public discussion.
Yeah, and Jim Shabilsky has a good point here. And I love what he says here. Jim says, with this information, we can approach, not just attack the situation. And I think that's so important is that this is an approach. It's not saying we have to do this, so you must cooperate with me. It's an approach of saying, how do we together figure out a solution? Because individually, it's going to cost us a heck of a lot of money, heck of a lot of time, heck of a lot of effort to do what we need to do. But together, perhaps we can essentially solve this problem. Bill brings up a good point here. He says, on a related note of cooperating with others, national cooperative contracts for the purchase of goods and services are becoming more popular. Are you able to comment on when these cooperative contracts may or may not be used? Might this also be another webinar addressing this down the road? From my understanding, 660303 addresses municipal interstate cooperation. Bill, that's a great point about these cooperative contracts. We see more and more of them now. And perhaps it's a different webinar. And Sarah, perhaps we can put this on the plate for next year's In the Boardrooms. I know we just finalized the calendar for that. But cooperative purchasing is something that is a separate issue from the 660301 agreements. Frankly, it's a separate issue from the 0303 agreements. 0303 agreements are what we would consider to be interstate compacts. And so we're not talking about interstate compacts on cooperative purchasing. We're talking about statutory authority to rely upon a bid process from some other jurisdiction in order to meet our requirements of lowest qualified bidder. It gets into Chapter 16 requirements at the state DOA level, and it gets into our requirements under 66013, what was it, 0131 that we talked about earlier. So I think Bill brings up a great point that we ought to address this in a separate forum, Sarah, about cooperative purchasing, and perhaps we could have a guest speaker on that who administers a lot of these contracts. We could certainly do that. So
Yeah,
thank
I would say thank you, Andy, for mentioning 2026. That was going to be the next thing I brought up as we wrap up for today was our 2026 dates have been chosen. Watch your inboxes for those dates to come out soon. The other point is Andy mentioned is we are looking for topics for 2026. So if you have a topic that you would like to see addressed at one of our in the boardrooms next year, please get in contact with me or Andy or Rebecca, Malia, anybody who has appeared on one of our in the boardrooms from Attolles Law or at WCA, and we'll be sure to get those on the list. So with that, I am not seeing any other questions. Andy, Rebecca, any last comments from you today?
Have a good day, everybody. It was an awesome discussion, and I hope everybody is incredibly enthused to go out and intergovernmentally cooperate with one another.
Perfect. All right. Thank you, everybody, and we'll see you on November 19th.
Thank you all.
Thank you, everybody.